Folks, welcome back to another Centre for Constitutional Studies interview video. And I'm here today with Professor Mike Powell to talk about the latest chapter in the back and forth between Doug Ford's government and the courts over the regulation of third-party political advertising in Ontario. So, Mike, we just had a big judgment about 2 weeks ago from the Ontario Court of Appeal, and the headline of that judgment is that the court has struck down a Ford government law that was passed just a couple of years ago using the Notwithstanding clause, which gets us right to the heart of debates that are taking place right now across Canada about how to deal with the fact that a number of provinces are getting, let's say, a little bit more trigger happy with their approaches to the Notwithstanding clause. So we're going to talk a bit about that debate in a few minutes. But Mike, just before we get there, and before we even talk about the Court of Appeal's judgment, maybe you could just walk us through the story or the saga of how the Ford government came to use the Notwithstanding clause to pass this now invalidated law back in 2021.
Well, thanks for having me, Richard. Very happy to be here. The saga really starts a number of years ago, where Ontario provincial politics had no rules that applied to third parties, which you might understand as interest groups. Could be unions, could be corporations, could be NGOs, any kind of group like that. And a number of different groups saw that there was no rules applying to them at all. There was no spending limit. And what they started doing was to spend quite large amounts of money on television advertising, on other forms of advertising, and mostly in ways that criticize the Conservative Party in Ontario. It was mainly union groups, although there was some advertising across the spectrum. So we had a no law that applied to limit spending, which is different than the federal level, and a dramatic increase in how much was being spent. And so sometimes these interest groups spent more money than even some of the political parties involved in the election. And so the Kathleen Wynne government introduced legislation that did some pretty orthodox standard things across Canadian jurisdictions, requiring third parties to register if they want to advertise during an election campaign, putting in a spending limit for how much money third parties could spend in an election campaign, less than what the parties could spend, because that's been the way the policy has tended to operate across the country. And then the most controversial part was introducing 6 months, a time period before the official election campaign began, where a spending limit applied to third parties. And so that's what eventually gets, a modified version of that is what eventually gets struck down. The Wynne government had put in place a 6-month limit. The Ford government extended it to a 12-month limit. So the year before the election, spending limits applied. And the rationale was we have fixed election dates now. And so interest groups are timing their advertising to happen before election campaigns happen or before spending limits kick in. And so this, the Wynne law and the Ford law were tailored to the new third-party behavior and spending patterns, given that we had fixed election dates and everybody could time when they wanted their advertising to happen so it would be as effective as possible.
So maybe you could walk us through the Superior Court's judgment, which invalidated the law back in 2021 on Section 2B grounds.
Right. So Justice Morgan of the Superior Court struck down those portions of the Election Finances Act that had been, some of them which had been amended by the Ford government, some of which had been in place before. And his conclusion was that the extension of the pre-election campaign spending limits from 6 months to 12 months was a violation of freedom of political expression in the Charter and could not be saved as a reasonable limit in a free and democratic society under Section 1. And really the core of his decision was the choice to extend from 6 to 12 months the pre-writ regulated period without increasing the spending limit. So the spending limit was $600,000, indexed for inflation. It was that when it was 6 months, and then it was still $600,000 when it was extended to 12 months. So that was the amount a third party was permitted to spend. And he found that was more than minimally impairing, because if 6 months was a reasonable limit, how could 12 months with the same amount of money being permitted to be spent, how could that also be reasonable and not more than minimally impairing? And so he really strikes it down because of the shift from 6 to 12 months and the evidence on the record not explaining why 12 months was needed. We had evidence from former Chief Electoral Officer of Canada saying 6 months would be reasonable, but so would 12. And he says that that wasn't enough to justify the limitation. The Ford government responds to this by keeping the law intact, but adding the notwithstanding clause, shielding the provisions of the law from being struck down for being contrary to freedom of political expression. That then leaves the Working Families Coalition and others to go back to court, but this time arguing it's not a breach of Section 2B, but a breach of the right to vote in Section 3 of the Charter.
So just to sum up where we are at this point in the story, then, Ford government's law gets struck down by the Superior Court on free expression, Section 2B grounds, and it then gets revived by the Ford government using the notwithstanding clause. Now, normally, a lot of folks who are watching might assume the notwithstanding clause will function by preventing judicial invalidation of a law, at least for a renewable 5-year period. That's, the short version of what the notwithstanding clause does. But here we are, just a couple of years down the road, and we have the Court of Appeal invalidating that revived law. So how is it that the Court of Appeal manages to invalidate a law that was passed and effectively revived using that shield of the notwithstanding clause?
Right. So there's a lot we don't know about the notwithstanding clause because it hasn't been used that much in Canada outside of Quebec. The Ford government has been more willing to use it. So lots of unknowns. But one of the clear things from the text of the notwithstanding clause in Section 33 of the Charter is that it does not apply to what the Charter calls democratic rights. And that's the right to vote in Section 3, and then some kind of structural rights that require Parliament to meet once a year or the legislature to meet once a year, and that you have to have an election at least every 5 years. And so those are, the notwithstanding clause cannot be used to shield a breach of Sections 3 to 5 of the Charter. Why is that the case? Because otherwise you could use the notwithstanding clause to essentially end democracy or end the fairness of elections by banning the people who you don't want to vote if you're the government from voting. Okay, so it shields democracy, makes sure it operates. So in this case, Section 2B, political expression, is subject to the notwithstanding clause. And the courts, the lower court and then the Court of Appeal, both found there are no substantive limits on the use of the notwithstanding clause as long as it's properly invoked in the legislation, as it was here. There's nothing further for the courts to do. But it still leaves open to the claimants the possibility of bringing a claim under Section 3 because Section 3 is not subject to the notwithstanding clause. And so we usually deal with any campaign finance case under Section 2B, but there's a case called Harper at the Supreme Court of Canada where the Supreme Court, it was mainly about 2B, freedom of political expression, and third-party spending limits, but the court talked about a potential violation of the right to vote in this context because there's an informational component to voting. Okay, and so the 2B claim was about restrictions on spending by the third parties. The Section 3 claim is about whether there is an improper restriction on the right of voters to be able to meaningfully participate and how much information they need to hear from third parties to be able to meaningfully participate.
So let's drill a bit deeper then into the court's Section 3 reasoning in this recent Working Families decision, because there have been concerns expressed about the court's approach to Section 3, even by folks who are, strongly opposed to the Ford government's use of the notwithstanding clause in this case. And so maybe you could explain firstly, what Section 3 requires when it comes to voters' access to information. And then secondly, whether you think the court's judgment, as some folks have suggested, maybe stretches these requirements a little bit too far, or makes them a little bit more demanding, let's say, than they normally are.
Right. So the test under Section 3 of the Charter, well established, is the individual voter's right to meaningfully participate. And so the question became, once it moved to a Section 3 claim, what's the impact on the individual voter's ability to meaningfully participate? And the indications we had from an earlier case, the Harper case, was could there be a modest informational campaign run under the existing regulatory regime? And so what the Court of Appeal did here is, rather than focus on the test of meaningful participation, they looked at the Harper case and said, there's two standards that come from it. One is whether the restrictions are narrowly tailored, and two, whether a modest informational campaign can be run. So they moved away from focusing on how meaningful the participation was to these two standards of narrow tailoring and a modest informational campaign. The narrow tailoring test, I'm unpersuaded by, because to me it looks like that's importing a rights limitation analysis, which should properly be found in the Section 1 analysis rather than at the Section 3 stage. The dissent in the Working Families Court of Appeal case makes that same point. So I think the dissent is on solid ground there. I work on these cases a lot. To my knowledge, no one had suggested that narrow tailoring, that language in the Harper case, was a new standard to be used within Section 3, rather than simply a description by Justice Bastrash about what was going on in the case at the time. Now, the modest informational campaign, I think the Court of Appeal is on very solid ground there and using that as the standard. And so the question simply becomes then, on the evidence, was it possible for the claimants to mount a modest informational campaign? And the contrast is with a campaign that is extensive and expansive enough to persuade voters to change their minds. And there's evidence that you need to spend a lot of money to be able to change voters' minds with TV ads, okay? Less money if you're running a modest informational campaign on television. You simply want to inform voters of your view and get that on the table. Even less money if you want to run ads online. So spending costs have gone down for everything other than television advertising. It's cheaper to advertise in a newspaper. It's very cheap to advertise on social media. And Justice Morgan, in his second Working Families case, had taken note of that to say there isn't a Section 3 breach because there can be a modest informational campaign. Court of Appeal majority disagreed with that because they did not see a justification for the 12-month rule. So they focused on the extension again from 6 to 12 months rather than the amount of money that was permitted to be spent. And so $600,000 indexed to inflation, I believe it's $719,000. If you take all in what third parties can do, you can run a pretty aggressive series of ads on Facebook with $719,000. You can run not as aggressive a TV ad campaign, but still have a TV presence. So the Court of Appeal decision doesn't go into how much advertising you can actually get and whether that allows a modest information campaign. So leading to the dissent critiquing the majority for looking like it's turning the onus onto the government to justify at the Section 3 stage, when the onus is supposed to be on the claimants, whether a modest informational campaign could be run. So I think it's fair to say the majority at the Court of Appeal broke new ground in its interpretation of what the test should be. It has a two-part test. I think I'm much less persuaded on the first part, narrow tailoring being as something that should be part of the test. The modest informational campaign is there and should be part of the test, but the issue is whether on the facts a modest informational campaign could be run at all.
So just following on from that, the big question that I want to end with now is the question of how we respond to the shift that's taking place right now in the way that the Notwithstanding clause is viewed and used at least by certain provinces. And the Court of Appeal's judgment offers one possible answer to that question, right? Which is that we should look first and foremost to other sections of the Charter, sections that can't be overridden by the Notwithstanding clause, as a way of maybe reining in provincial governments that are arguably, for some people, becoming a little bit too trigger happy with Section 33. And so my question for you is whether that is a constructive response to the current situation, or conversely, whether it maybe opens up an inverse problem of courts effectively amending the Charter and reading Section 33 out of it by inflating the ambit of other rights. So is the Court of Appeal pointing us, this is a reductive way to put it in the end, but is it pointing us in a good direction or a bad direction when it comes to dealing with Section 33?
Right. So set aside, if you don't mind, set aside for a second whether it's good or bad. I'd argued in the past in an article on the right to vote, it's inevitable if the Notwithstanding clause is going to be used more often, and especially in relation to political rights, because it can be used in relation to freedom of expression, freedom of association, which pertains to political parties, quality rights, which matters a lot for municipal elections, because that's how voting rights get protected. If governments are going to use the Notwithstanding clause in relation to political rights, inevitably claimants will funnel their claims into Section 3 where it's permitted. So there will be a lot of pressure on courts to potentially expand the ambit of Section 3. So I think that, just as a descriptive matter, it is happening in working families and will continue to happen. Now, is it a good thing or is it a bad thing? The Notwithstanding clause is part of the text of the Constitution. It is drafted in a particular way, so there are sections of the Charter it does not apply to. So there is nothing illegitimate about interpreting those sections of the Charter and to see what content they have when new factual scenarios and new government legislation comes up. So I see nothing wrong about it. Now, does it have some effects down the road? Supreme Court likes to tell us there's no hierarchy of rights in the Charter. Looks like a hierarchy of rights to me if some rights are not subject to the Notwithstanding clause and some rights are subject to the Notwithstanding clause. So that's one point. Another point is we have to see how responsibly governments use the Notwithstanding clause in the future. And so maybe the Notwithstanding clause was simply poorly drafted by the framers of the Charter. They excluded, in terms of political rights, they excluded Section 3, which I think was the correct choice to protect democracy, but they allowed Section 2B and association to be subject to the Notwithstanding clause. And maybe there's an argument that it could be used productively in some ways in relation to those provisions, but when those are applicable in the political rights context, political rights and freedoms, it means governments could do things that really harm basic, non-controversial norms of democracy. Could make it illegal to criticize the government, for example. Could make it illegal to form or join a political party. Could ban a political party. So those are maybe sound like extreme scenarios. I think democracy is fragile, and if we look around the world, there are examples of all those things I just listed. Hopefully, Canada will not go down that road. But if it does, then you know, an expanded ambit for Section 3 doesn't seem as controversial. It seems preferable to allowing a state of affairs where the basic foundational bedrock norms of democracy are undermined. And so defenders of the Notwithstanding clause say, well, those haven't happened yet. We shouldn't consider the extreme scenarios. But I think given the fragility of democracy around the world, we have to think seriously about the most potential troubling uses of Section 33 and what a legitimate response based in the text of the Constitution could be.
Mike, that was really wonderful. Thanks so much for your insight, and thanks so much for joining us today.
Thanks for having me. It's been a pleasure.